if you started thinking about doing an estate plan, most likely the thing that you've thought about is doing a will. And I can't tell you how many times people, contact our office and they start out with, "Hey, listen, my situation is very simple. I just need something written down. I just need a simple will. I just want everything to go to my spouse. And then when we pass away, everything goes to our kids equally," right? And that's some version of that, but everything goes to each other. When I pass away, I want everything to go to my wife. When she passes away, everything comes to me. And then when we both pass, everything gets split equally between our kids. And so most people have heard of a will. It's probably the most common estate planning technique that most people are familiar with. People look at it as the simplest, the most cost effective. So is it right for everybody? When should you consider doing more than a quote unquote simple will? Well, there are some instances where I might say a will makes sense. I think for you to determine whether or not it makes sense for you, the first thing to think about is, are you in a state, a state in the United States where probate is simple, right? And now probate is necessary primarily to transfer title, to transfer ownership to whoever you've left, whoever you're leaving, however, to transfer those assets. So for example, if I own my house and it's in my name, Justin Stivers, individually, when I die, if I have a will and I leave the house to my son will have to take the will, go to court, go to probate court, and at the end of that process, the judge will then allow the house to be transferred to my son. Is that process simple, right? In Florida, where I primarily practice, it's not simple, right? So for my clients who have any piece of real estate and it's in their name individually, I'm most of the time going to advise that we do some other type of planning technique other than a will, because a will is not going to avoid probate. If you don't have any real estate and you just have money in bank account, well, you could potentially put beneficiaries on those bank accounts. The pro of that is you avoid probate. The negative, the con of that is, well, if you leave money outright to your daughter, let's say, you list her as a beneficiary on your brokerage accounts, your investment accounts, your checking, your savings accounts. You avoid probate because she'll be able to go into Bank of America, Wells Fargo, Raymond James, wherever, and withdraw the money immediately because she's listed as the beneficiary. But if she's married and she gets that money outright, if she were to divorce from her spouse the next day, this is in Florida primarily, then that spouse is going to be able to take 50% of that inheritance that you left her because you just left it to her outright. So in that case, listing her as a beneficiary might not be the best option. So you have to think about it. How do you want things to go? Again, if you just want your kids to get everything outright, a will, and you're not worried about probate, maybe you have a will and you just list your kids as beneficiaries. But you have very little control in that instance. If you have young kids, you probably don't want an 18-year-old getting all the money that you're going to leave them. So you wouldn't want to put them as a beneficiary. If you have kids under the age of 18, they can't just get the money outright. So a will really is limited in the amount of control that you can have. It just basically gives everything to them outright. The other thing is, it's probate's public record. So when you have a will, everybody's going to look at it. Everybody's going to know what you had, because there has to be what's called an inventory done in the probate, where someone's going to list all your assets, what you have. They're going to list all your creditors, all your debts. And so there's opportunity for people to take advantage of your kids, of your beneficiaries, because they're going to see what they're getting. It's all public. So there are instances, again, if you're not concerned about probate, having a simple will might be okay. If you're not concerned about control, if you're just okay with them getting everything outright, then a simple will might be okay. If you're not concerned with your spouse, if you're married, remarrying, and then them getting divorced, and now potentially half of that inheritance going to that new ex-spouse or maybe that new ex-spouse's children, then having a simple will is okay. Obviously, most people are not going to be okay with that. So I would encourage you, if you're starting to do your research on, what type of planning I should get, ask some of these questions, right? Don't just look at it. My suggestion would be, don't just look at it, well, I only have $100,000. I only have a house. It's simple. I want everything to go to my spouse, and then we want everything to go to our kids. That might be simple, but how that happens might be a little bit more complex. So ask your attorney, if you're working with one, some of those things that we talked about, and make sure that it and if you're okay with all of that, great. But if you want to have a little bit more control, if you want to avoid probate, if you don't want it to be public record, if you want to make sure that the inheritance that you leave to your kids isn't potentially lost in a divorce if they were to get divorced, or subject to creditors or anything like that, then you might want to do a little bit more planning that would involve probably a trust, right? And it doesn't mean that your planning is complex. It just means that maybe having a simple will isn't the best option, or there's potentially other even better alternatives out there for you.